Welcome to the NAMI New Jersey webinar lecture series. My name is Meredith Mason-Blount, and I am the Executive Director of NAMI New Jersey, and I'm thrilled to have you join us today. Today's webinar is called the Health Insurance Portability and Accountability Act of 1996, or HIPAA, and Privacy and Family Information Involvement. We have a very distinguished speaker with us today to inform us about the complexities of this issue. Joining us today is our presenter, Phil Lubitz. Phil Lubitz is the Associate Director of NAMI New Jersey, where he is responsible for the advocacy programs and law enforcement education. He has more than 40 years of experience in the public mental health system as a therapist, administrator, and family advocate. He is a frequent newspaper, television, and radio contributor on mental health issues throughout New Jersey. He is currently serving as the chairman of the New Jersey Behavioral Health Planning Council. He is also responsible for adopting the state plan for supporting the family caregivers of people with a mental illness. He was awarded the Senator Paul Wellstone Award for Mental Health Advocacy by the New Jersey Association of Mental Health and Addictions Agencies, and the Governor Richard J. Cody Mental Health Champion Award from NAMI New Jersey. Most recently, he has won the prestigious 2019 Anne Klein Advocacy Award. He received a bachelor's from George Washington University and a master's in social work from Rutgers School of Social Work. So we are very thrilled to have Phil do this for us, and I will turn it over to you, Phil. Thank you.
Thank you, Meredith, for that very kind introduction. So today we're here to talk about HIPAA, the Health Insurance Portability and Accountability Act. Before I start, I do have to say that you're going to be hearing this presentation from a social worker and not an attorney. So what you're hearing today, although it's meant to be informative, is not meant to be providing legal advice. So why don't we get started with the presentation? So today we're going to talk about three major privacy laws: HIPAA, 42 CFR Part 2, and FERPA. And I'll quickly give you a rundown on what each of those are. So HIPAA, again, the Health Insurance Portability and Accountability Act, is a privacy rule that protects the privacy of individually identifiable health information. Then there's the equivalent of that for federal drug and alcohol patient records and confidentiality, and that's generally referred to as 42 CFR Part 2. And these regulations impose restrictions on disclosure and use of alcohol and drug abuse patient records. Generally, they're a good deal stricter than HIPAA, and with the there was just recently action in Congress that changes those. So we're going to be talking about what is in existence right now for CFR Part 2, and we're also going to talk about coming changes to that. So, well, why don't we talk about that right now, actually. So 42 CFR is regarding records that identify diagnosis and prognosis of the treatment of patients who are receiving drug and alcohol treatment and who are assisted either directly or indirectly by the federal government. And to a great extent, almost all drug and alcohol treatment in the country in some way is involved with some funding from the federal government. So most agencies are and providers are covered by that. So who is covered? So anyone who presents themselves as a drug and alcohol treatment agency, and also if you were in just a general medical facility and you were working with people in that general facility who also proposed to be drug and alcohol treatment providers, those people are covered. And again, a facility that itself is providing drug and alcohol treatment. So the key piece of CFR, and the reason it's so much stricter than HIPAA is that there are 10 specific criteria that must be followed to meet the requirements of CFR. And generally, you have to be very specific of the name of the person who's being, whose records are being requested, who is requesting them, what is requested, what will the disclosures be used for, how much information will be disclosed. It requires a signature, requires a date. It requires a statement of the consent is subject to revocation. That means the patient could ask that they no longer release information. And when the date at which the permission will cease to exist, and then notice on the prohibition of the redisclosure. Now, what we're going to find in all of these, excuse me, confidentiality laws is that there's a provision that a good deal of the restrictions are waived in the event that there is a medical emergency for the patient. So an easily understandable case for 42 CFR would be if someone has an overdose and is receiving a Narcan reversal. You know, that information, that's in a medical emergency. So some of those requirements for that 10-point release would be waived. So as I mentioned a minute ago, and this is it's generally called the CARES Act. This one is the big bill that was passed just last week in the Senate, in Congress, signed by the president. And most of us are familiar with the economic pieces of that act, but that also did a number of other things. Again, the Coronavirus Aid, Relief, and Economic Security Act. So it directs the Secretary of the Department of Human Services to implement new rules for CFR, 42 CFR Part 2 disclosures that are going to relax a good deal of those pieces. So you're no longer going to have that 10-part release of information, although you're going to continue to need a signed release for drug and alcohol records. But the uses and terms of what can be released are going to more closely mirror HIPAA. And we're going to go on to see what those pieces are. So you're going to find that generally for business use and for treatment, the restrictions on release of information under CFR, 42 CFR Part 2 are going to be relaxed. Again, that's likely to take effect within 12 months as new regulations are adopted. So FERPA is a Family Educational Rights and Privacy Act. And this has to do with individual student records held by school or education agencies. Okay. So FERPA is a federal law that protects the privacy of student education records. It gives the parents certain rights in regard to children's records. And those rights transfer over to the student when he or she reaches the age of 18. That's the age of adulthood for FERPA. So, FERPA disclosure. School officials may disclose without consent information from students' educational records in connection with an emergency. So again, there are clear restrictions on the amount of information that schools are allowed to disclose under FERPA. So, you know, if a student is receiving some counseling in school, that could be that could remain confidential to a certain extent. However, in an emergency, and you know, the area I think that is we might be most familiar with is, say, a college student away at school, away from his parents, and the student starts receiving or having some psychiatric distress. If that reaches an emergency situation, the school clearly is permitted to contact parents to let them know about that. There seems to be a good deal of confusion on the parts of a lot of educational institutions, but FERPA, although it protects privacy of students, it clearly allows that. Another piece of FERPA that's misunderstood, you frequently hear that parents say, well, I'm paying his tuition and he's on my income tax, and yet the school won't send me his grades. Well, that has nothing to do with FERPA, because FERPA clearly allows the institution to disclose educational records, including financial records, to the student's parents if the student is claimed on the parent's income tax as a dependent. So when the school tells you we can't send you the grades, that's really a decision they're making on their own, a policy decision. It is clearly permitted under FERPA. Okay, so that was very, very quick overview of the drug and alcohol provisions regarding disclosure and the educational requirements as well. But today's presentation is primarily has to do with HIPAA. So why is medical privacy important? And I think it's important to state at this time, one of the other misunderstandings about HIPAA is that HIPAA isn't, in almost all cases, isn't specifically about mental health treatment records. HIPAA has to do with all health records. So whether you're being in treatment for heart disease or diabetes or psychiatric problems, the general provisions of HIPAA are the same for all of those situations. But it is important to protect medical privacy. So HIPAA does protect sensitive information about mental health treatment, and again, all health treatment. It affords consumers control over their own medical records, especially in the case of mental health treatment. There's a good deal of stigma against that. So if information is released, you only want that to be with the consumer's discretion. But HIPAA also provides families and caregivers access to some essential information. And we'll talk about that a little bit later. And it increases the efficiency in communicating vital medical information. So, we're very clear, there's a lot of talk now about electronic health records and how beneficial that can be when good, clear medical information is available with the patient's permission to a variety of medical professionals who may be involved in the person's treatment and who may not be communicating on a regular basis. So a quick history, HIPAA has been around for a long time. It was adopted in 1996. Part of the confusion about HIPAA is that there were some very, very rigid regulations that were proposed during the Clinton administration. But those regulations were never adopted. That process stopped when the Bush administration came into office, and the final rules were published in 2002 under the Bush administration. And at that time, there were many changes to proposed regulations, including provisions that actually made it easier for family members to gain information. So it's important to understand who is covered by HIPAA. So one, public and private health plans like Medicaid, private insurance, and Medicare. Health providers who transmit records electronically. So that doesn't mean your mental health provider has to, say, have an electronic health record. Think that there may be still providers that are keeping written records, handwritten records, typed records. But almost all of those providers now in our world bill electronically to their insurance companies. It's generally much more efficient to do that. So that under HIPAA counts as someone who transmits records electronically. Again, the next point. And then healthcare clearinghouses, like, so there are many billing services or services that are middlemen in medications, management information systems. They're all covered by HIPAA. So it's important to point out that who is not covered by HIPAA, and that primarily is family members. You as a family member are not covered by HIPAA. So, you're free to share information with professionals. You probably want to use your judgment in sharing it with family and friends. And nowhere in HIPAA does it prohibit you from sharing information with professionals. Also, NAMI is not a covered entity because we don't keep private or electronic health records. We do not provide therapy. We provide support. But, it's still important to know that, our NAMI policies and ethics do counsel us to be very guarded about the privacy of the information that people share with us, and really not to share information without the expressed permission of those who have given it to us. Okay, so what information is protected? So any information essentially that identifies a person as a past or present recipient of mental health care or treatment, including the payment for provisions of health care. Information that identifies the individual or can reasonably be used to identify the individual. So things like date of birth, and certainly social security numbers, that becomes even more important in the time of big data, where seemingly insignificant information when tied together has been shown to be able to clearly identify someone. So you don't want to, HIPAA will protect disclosure of information that's going to be able to identify an individual. So then if common identifiers are removed and there's no way of identifying that information, then HIPAA doesn't apply. So you might want to know if your family member is diagnosed with schizophrenia. Without permission, the healthcare provider, would have to be guarded about providing that information. However, if you were to ask, what are the common symptoms of schizophrenia, and what are the best treatments for schizophrenia? What are the common medications used to treat schizophrenia? What is the typical course of schizophrenia? Those things, you're not talking about an identifiable person. So those are all questions that not only is your provider permitted to discuss, but they're questions your provider should be discussing. Okay, so another piece that's not really understood in HIPAA is signed consent is optional. So under HIPAA, and I'll show you, we'll go look at the regulation in a minute, HIPAA does not require a signed release of information. However, it does permit the provider to both obtain consent, and the provider can establish a policy that for their treatment program or their practice does require a signed release. You know, as NAMI members, we talk to providers and try to address this point, and it's clearly understood that the course of treatment, a person's chance of recovery is much improved if he has involved family, supportive friends involved with the treatment. So, you know, why would it be beneficial for the consumer to be with a agency that has policies that really make it much more difficult to involve supported people? Okay. So the protected health information, this is generally referred to as PHI, may be disclosed without a signed authorization for treatment. We just went over that. Although the person, they can have their own policy, payment, and healthcare operations. So these are provisions also that were previously not involved in 42 CFR Part 2. Remember, those were 10 specific things under drug and alcohol treatment that could be disclosed. With the change that's coming within the next 12 months, these things will all take place. So those things should be a lot easier to do in drug and alcohol treatment. So this is actually the preamble to the HIPAA requirement for disclosures. So let's read that. A covered entity may use or disclose protected information without the written consent or authorization of the individual. Okay, so that says you don't need written consent, provided that the individual is informed in advance of the use or disclosure and has the opportunity to agree or to prohibit, restrict the disclosure. So typically what is required in HIPAA is that you just ask the person, is it, Phil, is it okay to speak with your mother about the appointments we're going to set up? You know, Phil says, sure. So that's it. And in that case, the provider can do that. If I say no, in almost all instances, and we'll talk about that, the provider cannot share that information. Although, you know, we counsel the providers that, again, they should be working with the consumer over time to discuss the benefits of involving supportive family members and friends in their treatment. There's some disagreement about whether or not this situation, Phil, can I disclose some information to your mother? Can I tell her when your appointments are going to be? And Phil just says, doesn't really say anything. So HIPAA, it's important to note, doesn't say that you have to get their permission. What it says is that you have to give them either the opportunity to agree or to prohibit the disclosure. But it doesn't say, but it doesn't say that they have to agree. It says you have to give them the opportunity. So I would say, and again, I'm not proposing to give legal advice, but the simple wording of HIPAA would seem to indicate that it doesn't absolutely require permission. What it requires is you give the opportunity to either agree or to disagree. So if you don't have to sign a release of information, and again, a particular agency can adopt their own policies requiring that, although it's not necessary. There are a couple of times when you do have to sign under HIPAA. And remember again, this has to do with all medical treatment, not only mental health treatment. So we've all probably had the experience where we go to the doctor's office, and we may have been going to the physician for quite some time, and all of a sudden we're given a stack of papers to sign. And that essentially is this notice of privacy practices. So HIPAA does require all providers to give people notice of what their privacy policies are. And that requires a signature, just that you've received those. Also require that they're easily available. So if your family member is seeing a mental health professional, the mental health professional knows that you know that they're being seen, so the provision of not disclosing information that identifies a person as a recipient of mental health services is not violated. Well, in fact, all mental health providers, no matter whether or not your family member is seeing them, are required by this provision to make public their privacy policies. So I think it's a good idea if you have a family member seeing someone, ask to see their privacy policies. And, you know, I've had the experience where, you know, families have called me, have had difficulties with an agency who have used very, very restrictive privacy policies. And before I've gone in, I'll go to their website. One, they should have, the law requires them to have the policies on their website. But it turns out the policies are really just what we're talking about here, that you don't absolutely need a signed release of information and the other things we're going to discuss. But the people who were working for the agencies didn't even know their own privacy policies. So it's important to either ask for the privacy policies or go online and try to find those privacy policies. It might surprise you, it might surprise the treating professional. Another exception and a misunderstood exception are something called psychotherapy notes. Now, most mental health providers are going to think that all of their records are psychotherapy notes and therefore are covered by this particular exception in the privacy rule. So psychotherapy notes, it's true, do require a written consent on the part of the consumer. However, there's a great misunderstanding of what constitute as psychotherapy notes. So psychotherapy notes are notes separated from the rest of the medical record pertaining to the details of therapy counseling sessions. And it's important to understand what they don't include. They don't include information about medications, clinical test results, diagnosis, functional status, treatment plans, symptoms, prognosis, or progress to dates. Actually, you know, those are the things that most caregivers are interested in. Psychotherapy notes, you know, I'll give you an example. As a therapist, you might be seeing someone, and during the course of the time, you may be coming up with certain ideas about what's occurring with that person. And over the course of time, you might be testing those things out to see if your assumptions are true or not true. But in some cases, those might be very disturbing things. And because medical records tend to take on a life of their own, whether they're accurate or inaccurate, generally, a therapist is taught not to include just their assumptions in those records. So you might be keeping those separately. You might keep handwritten notes away from the case records. Those are psychotherapy notes. For those, you would need a signed release. However, those very same handwritten notes, once they get into the case record, they are no longer psychotherapy notes. Just physically putting them in the case record makes them now protected health information. And then they would be under the same procedures as regular protected health information. They wouldn't necessarily need a signed release of information. So another issue that sometimes arises when we're talking to professionals about sharing information with caregivers so they can provide their best support possible is the relationship of HIPAA to state law. So generally, federal law will preempt state law, but that's not the case in HIPAA. So there's an exemption in HIPAA that if state law is more protective of privacy than HIPAA, then the state law prevails. And if there's a dispute about that, Health and Human Services makes the determination. And it's also then important to know HIPAA was meant to be a floor. It's the lowest amount of protection for the records. So states were allowed to enact laws that were much stricter about the release or the sharing of medical information. However, New Jersey law, when we looked into this, and I can say that Disability Rights New Jersey and NAMI New Jersey collaborated by taking the Department of Human Services in New Jersey to Superior Court over a misinterpretation the state had made, making the records much more difficult to receive. So we were able to show that actually New Jersey law is a good deal less restrictive than HIPAA. And this is the citation. So I think it's worthwhile just to read it so we're clear on what New Jersey law says. Nothing in this section shall preclude disclosure upon proper inquiry of information as to the patient's current medical condition, which again, psychiatric conditions or medical conditions. So nothing shall preclude disclosure to any relative or friend or to the patient's personal physician or attorney if it appears that the information is to be used directly or indirectly for the benefit of the patient. So again, New Jersey's law had allowed information to be released to family members if the information was going to be used for the benefit of the patient. So the Attorney General's office in New Jersey agreed then with NAMI New Jersey and Disability Rights that HIPAA provisions not requiring the release of information were not preempted by New Jersey law. Okay, so the uses and disclosures with the individual present. If the individual is present, okay, so as we said a while ago, the first thing you want to do is obtain the individual's agreement. It's not necessarily to document in the record, but we recommend to mental health professionals that should they ask Phil if it's okay to tell his mother about their appointment schedule, that yes, they go ahead and they document that in the record. If the individual is present, you provide them with the opportunity to object. And if they have no objections, or if you reasonably infer from the circumstances based on the exercise of professional judgment. So let's see if we can get that. So I think generally what you say on this one is if, say I have come to my appointment and I have my mother and father with me. So the professional can tell from that I don't object to my mother and father knowing that I am a recipient of mental health services because I've, of my own free will, come with them. So again, they can use their professional judgment to see that I don't object to that. There may be other parts, but like if I were to ask if my mother and father can come into a family session, or if in the presence of my mother and father, I start to talk to the therapist about some things that would be considered protected health information. So if I'm doing that of my own free will, the therapist doesn't have to stop me and then say, Phil, you better sign a release of information because your parents are here. Or he doesn't have to say, Phil, are you sure that you want to give this information, or do you want to object to it? You don't have to do those pieces because you can reasonably infer from the circumstances and based on your professional judgment that Phil doesn't object to my parents being privy to that information. So there are times, though, when the person isn't there to be given the opportunity to agree or object. So the clearest one would be in an emergency, right? In an emergency situation, I think if a person ends up in an emergency room, it's probably considered emergency situation, or if the person lacks capacity to agree or object. The provider may disclose health information to a caregiver if it's in the best interest of the person based on the provider's professional judgment. But the provider can only disclose that information that's directly relevant to the individual's involvement with the individual's healthcare. So why don't we take that one? That's a pretty long run-on sentence there. So say, I'm going to use Meredith as an example here. Meredith takes me to my doctor's appointment. She walks in, says, Phil, I'll see you later. I'll see you after your appointment's over. And then she leaves. So Meredith comes back in, say, 40 minutes and say, is Phil ready? Is his appointment finished? And remember about that restriction, you don't want to give any information that would identify the person as a recipient of mental health or any healthcare service. But in this circumstances, we know that, and the provider knows that Meredith already knows I'm a recipient of services because she brought me there. So they can share, Meredith, no, Phil's going to be about 5 or 10 more minutes. Why don't you just sit down and have a seat, and he'll be ready soon. So to their observation, I'm there, Meredith's there as my ride. So they can give Meredith information that has to do with my transportation. But could they say to Meredith, oh, by the way, Phil has a medication change today? Probably not. Because again, their observation is Meredith's involvement with me is my ride. She can receive information about transportation, but it doesn't appear, they're not clear that her involvement with me has anything to do with medication or my actual treatment. Same situation, my mother takes me, Mrs. Lubitz, why don't you have a seat? Phil's going to be done in about 5 minutes. Oh, by the way, he is having a medication change today. So the question would be, why could they say that to my mother, but they couldn't say it to Meredith? And the reason really is not that I'm related to my mother. The reason would be, maybe they know, or they do know, that not only is my mother taking me to the appointments, but she's taking me to the pharmacy, or she is monitoring my medication, or she is reporting back to the therapist if I'm taking my medication, or if there are any effects from my medication. So her involvement with Phil, the patient, is a lot different than Meredith's. So the provider is permitted to share more information with her because of her involvement with the individual's health care. So the other part is disclosure when the person lacks capacity. And in New Jersey, the definition of this decision-making capacity is the determination that a patient lacks decision-making capacity shall be based upon an evaluation of the patient's ability to understand and appreciate the nature and consequence of a particular mental health care decision, including the benefits, risks, and alternatives to the proposed mental health care to reach an informed decision. Okay, so you have to be able to have a capacity to balance the good parts and the bad parts, and what will result if you do take the treatment and what will result if you don't take the treatment. Okay. A good example of this, and remember I said when we asked if Phil, if it was okay to share information, and I said, and Phil said no, and I said no means no in most circumstances. A clear example of that would be, Phil, can I tell your mother that I'm going to be seeing you, 3 times a week for probably the next at least 3 months? And I say no. So, and I would say no, that's not my mother. That's an alien in my mother's body. So I said no, but does Phil actually have the capacity to make an informed decision about that? Phil, clearly does not have that capacity. So at that point, the question should be, did Phil give consent for treatment? The question should really be, can Phil actually give legal consent? And, I would argue, and I think most people would agree, Phil does not really have the capacity to give legal consent. And therefore, the provision in HIPAA that allows the professional to use their judgment should come into play. Although there are some, just one other test that goes along with that. So the responsible healthcare professional in determining that capacity would state so in writing. He would give the nature and the cause, probable duration of the patient's incapacity, and he would document that in the record. In addition, a second professional would also have to confirm that that decision that the person lacks capacity. Also, the mental health professional would need to inform the patient that he would have a right to contest that. Okay, and then the statute gives the process for how one would go about contesting that. So this is the part that's, we want to reinforce that no treatment provider is precluded from accepting information from families or other knowledgeable about the individual's treatment needs. And this would go as far, including his treatment history or her treatment history, which also can be very informative in current and future treatment. It's not unheard of to have professionals refuse that, even though they are permitted. I would suggest that you write to a person, and if the professional is really very non-communicative, I would send that in registered mail to at least document that the professional had the appropriate information. So unless the individual objects, and again, we don't, under HIPAA, require a signed release, although an agency or a professional could have that requirement in their privacy policies that, remember, you have the right to see. There's nothing that would really prevent them under HIPAA from responding to your questions. But remember, HIPAA itself doesn't mandate that the professional has to do it, right? HIPAA says the professional is not required to, but it does not mandate that the professional has to give you that information unless you have the permission. So covered entities are permitted but not required to make disclosures other than to the individuals regarded all records pertinent to their own care. So the only person they're absolutely required to give the information to is the person receiving treatment. And there's some limitations on that as well. So why don't we talk about that right now? So law enforcement and criminal justice, there are certain circumstances here where they would give the information to law enforcement. Generally, you're going to require a court order or a subpoena. One of the things we caution families about not using too frequently, but in the case where either a person is lost or missing, or sometimes the person has become involved in the treatment system and may have gone to an emergency room, to a hospital, to an inpatient setting, to a state hospital, to a discharge. And, along the way, the people have misused HIPAA to refuse to give any information at all about the patient, so that a family can go some time without having any idea about if their family member is living or dead. In those really extreme situations, worse comes to worse, you can always file a missing persons report. And again, HIPAA then has an exception for law enforcement to try to locate that person and find out where they are. And HIPAA does not provide, although it may prevent the mental health people from informing you, it doesn't prevent the law enforcement people from informing you on your family member's location. But what HIPAA is pretty strict about a person having access to their own records. Okay, so if I were in treatment, I wanted my own records. There should be a policy in the person's, again, there's privacy policies we discussed about how you would do that. But a HIPAA certainly in most cases allows you for access to your own records. Psychotherapy notes, remember those things kept outside of the record, they may be an exception. So not only do you require usually a signed release for those, but there may be something in those records that would be harmful to you if you knew them. So, you know, an example of that might be, say in the course of treatment, the therapist comes to understand that the patient's father was sexually abusing the patient's sister. So, you know, that may be something that it would be harmful for, you know, if the patient wasn't aware of that, had never been aware of that, that might be something that would be harmful for the patient to learn through the release of the records. You know, I question again if that should necessarily be in a case record, but if it were, I think there'd have to be a lot of discussion of whether or not that should ever be released to the patient, whether or not they're requesting the record. But you're going to have to provide justification of why you're not going to do it. So there may be something, and it's not so infrequent because we said these records take on a life of their own. So something could have happened, been placed in a record when a person was, you know, 18 or 19 years old. The person, you know, could be 20 years later, and it was really misinformation. Or the patient, again, I should say the patient only has a right to the records that are generated by a particular therapist. So I might have been seeing a therapist, hospitalized, and then seeing another therapist. If I request my records, that therapist only has to turn over records of his treatment with me, even if he has obtained records, say, from the hospitalization. He doesn't have to turn over those records. Me as a patient, I would have to go back to the hospital and request the records directly from the hospital. So if I believe there's something that's inaccurate in my record, I do have the right to object to that. And then the covered entity has to make a reasonable effort to provide an amended version of that. They may disagree completely. So they aren't forced to amend the record, although, you know, for the sake of treatment, I think it would make sense. However, they are required then, if they aren't going to do that, to accept a written explanation from the patient, and that written explanation then has to become part of that permanent record. Okay, so then again, you have to develop written policies, and you have to train your workforce. There are enforcement remedies and civil penalties. They're rarely used, and actually they've been waived during this emergency, but people have been fined for this. So I'm going to tie it up by saying then it's important to read the privacy requirements very carefully and ask questions, make sure you understand them, and understand that sharing information can be and help being a supportive person, and never really accept a simple no. Now you're educated a lot more about HIPAA. And providers should really understand HIPAA, especially the part that's meant to help communication with family caregivers. They should take steps to protect privacy, but not overdo it to the point that they're shutting out people who want to be supportive. They should appoint a privacy officer, and especially make sure that the people they do business with, including their cleaning people, understand and have signed on to HIPAA, because you don't want people going through waste paper baskets and sharing information. Okay. So at this point, we reach the time when we're going to take questions, and I think we're going to switch over to Meredith, who is going to go into that question box to see if we have any questions that people are wondering about.
Great. Thank you so much, Phil. We do have a few questions, but I just want to tell everyone on the webinar now to open up your question and answer box and type in any questions, and we'll go ahead and get to as many as possible. So the first one, Phil, is actually a comment. I think it was a really good point that HIPAA protects all health-related treatments and diagnoses, and that is why it's important and why we should not just get rid of HIPAA altogether. So it's a really great point. Question, does a power of attorney override the HIPAA law?
Well, you know, you really can't overturn a law. A power of attorney could be, and I'm going to say at this point, again, I'm not giving legal advice. So in some ways, a power of attorney can act as a release. And I think maybe in a future webinar, we're going to talk about psychiatric advance directives. An advance directive is another thing that Division of Mental Health Services is saying acts as a signed release of information.
Great. Are there any protections for releasing information during what you think is an emergency but may not actually be an emergency?
Well, you know, the HIPAA law allows the professional to use their professional judgment. So I think in looking that, if there was a complaint, we'd have to determine if the circumstances would allow a reasonable person in the exercise of their professional judgment believe that it was an emergency situation, whether or not it turned out to be an emergency situation.
Great. Another question is, what is a family's recourse when the hospital or doctor uses HIPAA as a means not to disclose or cooperate with families, which is often the case with some of our families?
So again, I think the first step would be to go to the hospital's privacy policies. And, you know, the first thing I would say, because it's turned out to be true in many cases, that the reason, even those cases when a family member has not signed a release of information, the reason typically has been because they haven't been asked to sign a release of information. So a question I would ask is, has my family member been given the opportunity to agree or object? Okay, I think that's probably the first place to go.
That's a great point, Phil. Kind of along those lines.
Let me add, Meredith. So
Sure.
I would try to get a hold of one of their releases of information, if possible. And then when I was visiting my family member, if they're permitting visits, have them sign it at that time.
That's a great and actually a very closely related question is, can you even get a copy of the privacy policies if you're not the patient? For example, if I'm a parent and my child is in treatment and the agency will not share the information, can I just say, can I have a copy of your privacy policies and release of information form if I am not the patient myself?
So we can go back a few slides, but not only is it permitted, but it's required under HIPAA that the privacy policies be public, posted on a website and readily available. Again, whether or not you have a family member who's being treated there, they're just required for any entity that is covered by HIPAA.
Great. Is there a time limit on when you can obtain your records going back years or decades if you want to see your own records?
Again, I'm hoping that I'm saying I'm not giving legal advice. I don't believe there is. And actually, there's several provisions in the law that even say hospitals that charge, and again, entities are permitted to charge for the duplication of records, but for a number of entities, there's special statutes that have to do with a person's ability to pay. So actually, most people who are on like a Social Security income, their income would be low enough that they could make an appeal about the charge for duplicating those records. And it's quite likely they should be able to get the records without paying for their duplication.
Right. How does the law apply for international students or visitors to the country, or people who are on visitors visa? Does the law still apply to them?
It should, yes, right, because it has to do with medical records, not citizenship.
Right. So with the conversation about psychotherapy notes being separate from the file, can a
Yes.
court order get a copy of psychotherapy notes?
Again, I don't want to give legal advice. It's likely that well, that would be an interesting question, actually.
Okay,
Much the
great.
same, I don't want to give legal advice on that. I think you could make a case for not giving those up.
Okay, great. I think we have time for one more question if someone would like to send one in. One of the questions you did answer within your PowerPoint presentation, if you want to just maybe reiterate. Does HIPAA prevent families from giving information to the provider?
There's nothing in HIPAA that would prohibit a provider from accepting information. A provider may have, well, two considerations. One would be that piece that, about not identifying the person as a recipient of services. So the provider may not want to give away that the person is a recipient of services. So they may, really refuse to have any interaction in that regard. Providers sometimes worry about what's called the therapeutic alliance, that if they feel that if they have anything to do with the parent who the patient might be quite angry with, that will interrupt or disrupt the therapeutic alliance that they hope to have with the consumer or the patient. There are clearly ways around that, but that may be an instance where a treating professional may feel that way. In that sense, doing something in writing would be good. Those are the two areas. They may have ethical objections to dealing at all with a person outside of the individual, but those are actually pretty conservative therapists in general. But again, to answer the question, there's nothing in HIPAA that would prevent that. So if the person says HIPAA doesn't allow me to, they clearly don't have an understanding of HIPAA. Sometimes I take that little portion of HIPAA and I show it to a therapist, or recommend that people show it to the therapist, and I ask them to have the therapist explain it to them. And in many cases, it's going to be the first time the therapist or the mental health professional has ever seen the HIPAA regulation.
Great. Thank you so much, Phil. So this concludes our Q&A portion of the webinar. I'd like to thank everyone for participating today. Okay, we have one more question we're going to squeeze in, if that's okay, Phil. One more under the wire. Can different medical providers share patients' medical records with each other?
So in most cases, they should be getting some releases. to do that.
Between each other, right?
I
Great.
would say that.
Well, thank you so much, Phil. This has been very informative and great information. I just want to remind everyone on the webinar that when we end the meeting, you will be sent a link to do the survey. We'd appreciate if you take 2 minutes to fill out that survey. Within the survey, there's an opportunity to give us suggestions for future webinars. So this will be posted at our website and our YouTube channel, and the slides will be made available after the presentation. So any closing thoughts, Phil?
No, thank you, Meredith. You know, hopefully at some future date, I'll be able to do something on psychiatric advance directives, which is a nice fit with this. It helps to answer some of the questions and some of the limitations in HIPAA. Psychiatric advance directives are good workarounds.
Great, thank you so much. We will definitely have another webinar with that. Thank you. Everyone have a great day, and thank you for joining us.